A single mistake on the road takes just milliseconds. Two cars collide, glass shatters, and the kinetic energy dissipates. But the psychological impact of that physical strike doesn't stop at the intersection. The trauma of that one moment can radiate outward, striking immediate bystanders, relatives waiting hours away at home, and first responders arriving on scene. A broken bone is visible on an X-ray. A crushed bumper can be photographed, but psychiatric harm is invisible. This raises a difficult question in negligence law. When should a person be legally compensated for mental trauma caused by someone else's mistake? The legal system draws a hard line. It does not compensate for ordinary grief or distress, even when understandable. To claim legal damage, a claimant must prove they suffer a recognized psychiatric illness, like PTSD or severe clinical depression. Negligence law is not designed to mend every painful emotion caused by life's inevitable tragedies. It exists to compensate specific, legally recognizable harm. Because human trauma is limitless, but legal liability cannot be, the courts have engineered strict structural boundaries to define exactly who is allowed to recover damages. The courts establish this boundary by dividing victims into two distinct legal classes. A primary victim is directly involved in the accident, physically inside the zone of foreseeable physical danger. A secondary victim is situated outside that circle, suffering psychiatric harm by witnessing what happens to someone else. The legal hurdle for primary victims is remarkably generous. For secondary victims, the criteria are intensely restrictive. To understand liability for psychiatric injury, we have to map exactly who falls inside that physical danger zone and examine how the law filters the bystanders left on the outside. The stark line between these two groups is not a moral judgment on whose suffering is more real. It is a spatial proxy, a deliberate tool the courts use to control the floodwaters of liability. For the primary victim, everything hinges on physical location. The defining standard comes from the 1996 case, Page v. Smith. The claimant was involved in a car accident that wasn't physically serious, but the crash triggered a severe recurrence of his chronic fatigue syndrome. The House of Lords established a clear rule. If it was reasonably foreseeable that the defendant's negligence might cause physical injury to the claimant can recover for psychiatric injury. The defendant does not need to foresee the mental harm specifically. Endangering the claimant physically is enough to trigger liability for the resulting mental trauma. If a careless driver crashes into Paula's car and she escapes without a scratch but develops PTSD, her claim easily succeeds. She was directly involved in the crash, and physical injury was reasonably foreseeable. This generous standard leads to a common legal misconception. Many assume that severe trauma or heroic action at a catastrophic scene automatically upgrades someone to primary victim status. Students studying negligence often assume that first responders, like police or paramedics, are treated as primary victims simply because their jobs force them into close proximity with severe trauma. That assumption was tested and rejected in the 1999 case White v. Chief Constable of South Yorkshire Police, which evaluated claims from police officers assisting in the aftermath of the Hillsborough disaster. The House of Lords ruled that rescuers are only primary victims if they are personally exposed to physical danger or reasonably believe themselves to be. Witnessing horrific injuries is not enough. For primary victims, direct involvement in physical danger is the absolute prerequisite for liability. The court does not reward moral heroism, it requires physical endangerment. That leaves the secondary victims, the relatives, witnesses, and bystanders, locked outside the red zone of physical danger. The boundaries for their claims were forged by the 1992 case Alcock v. Chief Constable of South Yorkshire Police, dealing with the widespread trauma caused by the Hillsborough Stadium crush. To filter the immense volume of genuine psychological trauma emerging from the disaster, the House of Lords created 5 strict control mechanisms. Gate 1 requires a close tie of love and affection. The law presumes this tie exists for spouses and parents, but relationships like siblings must actively prove their closeness to the court with specific evidence. Gate 2 demands proximity in time and space. The claimant must be present at the accident itself or its immediate aftermath, marking an absolute cutoff for a valid claim. In an earlier case, McLoughlin v. O'Brien, a mother arriving at the hospital shortly after a crash saw her family still covered in oil and mud. The court treated that as the immediate aftermath. But in Alcock, relatives identifying bodies in a makeshift morgue hours later failed this test. Gate 3 requires direct perception through unaided senses. The court draws a razor-sharp distinction between witnessing an accident happen and being informed of the tragedy by a third party. Several claimants in Alcock watched the stadium disaster unfold live on television. Their claims failed because the broadcast did not show close-up, identifiable footage of their loved one suffering. If Leah receives a phone call from a neighbor that her brother Milo was hit by a bus, she fails the direct perception test. Even if she suffers severe psychiatric injury, being told about the event over the phone dooms her claim entirely. Finally, Gates 4 and 5 mandate that the injury must be caused by a sudden, shocking event, rather than a gradual accumulation of distress, and that psychiatric injury to a person of ordinary fortitude must be reasonably foreseeable. The Alcock criteria act as an intentional legal bottleneck. They ensure that only bystanders with the most immediate, unaided, and intimate ties to an accident can claim negligence against the defendant. These historical boundaries are still enforced today, even as the courts face constant pressure to expand the definitions of proximity and trauma. This tension reached the Supreme Court in 2024 through the cases of Paul, Palmier, and Purchase. These cases presented a unique challenge. The shocking events were not car crashes or stadium collapses. They involved relatives witnessing the sudden medical crisis of a loved one, caused by clinical negligence months or years earlier. The Supreme Court ruled that witnessing the deterioration or death of a loved one due to a failure to diagnose or treat is not legally equivalent to witnessing a traditional accident. The justices reasoned that to qualify under the secondary victim rules, the traumatic event must normally be a distinct, sudden accident, rather than the tragic culmination of a medical timeline. A massive policy fear drove this decision. Expanding liability in a clinical setting would mean doctors and hospitals owe legal duties not just to their patients, but to any relative who might later witness a tragic medical outcome. The Paul decision proves the courts are actively maintaining tight restrictions, refusing to stretch the zone of danger or the Alcock criteria into the realm of clinical deterioration. Why does the law enforce boundaries that feel so morally uncomfortable, highly artificial, and deliberately exclude genuine human suffering? The restrictions on psychiatric injury are entirely driven by legal policy. The system must protect the law itself from the floodgates argument, preventing a single negligent mistake from resulting in an unpredictable wave of lawsuits from everyone emotionally affected. There is also the need for fairness to defendants. The financial punishment for negligence has to remain proportional to the original careless act. The law requires evidential certainty, tests that courts can actually apply without relying purely on subjective emotion, and a strict clinical distinction between actionable illness and intense normal grief. This system is undeniably harsh. A person rushing to the hospital can claim, while a relative receiving a phone call cannot. A deeply traumatized rescuer goes uncompensated, while a physically uninjured driver recovers damages. Primary victims recover because they were physically endangered. Secondary victims are heavily filtered because they were merely witnesses to the danger of others. Psychiatric injury and negligence is a calculated balance. The law acknowledges that invisible mental harm is devastatingly real, but it enforces strict spatial and relational rules to ensure the legal system does not collapse under the boundless weight of human trauma.